This video has been prepared for general information purposes only. The information is not legal advice. Legal advice is dependent upon the specific facts and circumstances of each situation. The information contained in this video cannot replace the advice of a competent, licensed attorney. You should be sure to consult an attorney in your area to discuss your particular case.
Hello, my name is Michael Gambrell with South Carolina Legal Services. I'm the housing unit head, and I'm here today to explain a little bit about the eviction process in South Carolina. Now, South Carolina is a notice state, and what that means is that your landlord has to inform you that he or she is intending to terminate your tenancy. If you operate under a lease agreement, sometimes that means that your landlord has to inform you that they believe that you violated the lease and then give you an opportunity to cure that violation. Sometimes with regard to the payment of rent, the landlord has to inform you that you have not paid rent and give you 5 days within which to pay rent. Now, if that provision or that notice is located in your lease provision, then they don't have to give that separate second notice. But once the landlord has given you notice and that notice period has run, then the landlord goes to the magistrate's court and applies for what's called a writ of ejectment. Now, the application is this document here. And what the application essentially contains is a statement by your landlord indicating that he is a landlord and that you are a tenant of his, and to give the address upon which you reside, and also state or attest and swear that there is a landlord-tenant relationship between the two of you. The third thing that's required in the application is the landlord has to state upon which grounds the eviction is based. Whether or not it's based on your refusal to pay rent when rent is due, or whether the term of the tenancy has ended, or whether or not there's been a term or condition of your lease that has been violated. And then they have to state the specific grounds upon which that violation occurs. Once the application has been made to the court will then issue what's called a rule to vacate or show cause. And that is a separate document, and it looks like this. Now, the rule to vacate is a jurisdictional instrument, and what that means is that has to be personally served on you. And personal service means that someone, oftentimes the constable for that particular magistrate, will have to come to your house and stick it in your hand, or to give it to someone who is of the age of 16 or older. Now, if they come to your house and nobody's home, they're allowed to post it to the most conspicuous place, which oftentimes is your front door. Now, they have to do that twice. They have to come out and try to personally serve you on 2 separate occasions. And those occasions have to be separated by a period of 48 hours. And if you're not there on both occasions, they have to post it to the door on both times. And when they take that back to the magistrate will then mail you a copy. Now, it's important to know this because the rule to show cause states that you have 10 days within which to contact the court if you want to contest the eviction. And you have to either contact the court by telephone, by fax, by letter, or in person. As long as you make contact with the court within that 10-day period, the court will allow you to either request a bench trial or a jury trial. If you request a jury trial in your contest of the eviction, then that request has to be in writing, and those are per the magistrate court rules. But with regard to the mailing, if they're not able to personally serve you, the 10 days runs from the date that the rule is mailed. So you have 10 days from the date that the magistrate's court mails you the notice. Once you receive it, I would check on the instrument itself, the document, to see which date is indicated as the date of service, and then figure out how many days that you have to contact the court. It's very important that you contact the court within that 10-day period. If you fail to contact the court is going to grant the eviction, and they're going to issue what's called a writ of ejectment, and we'll get into that in just a minute. If you are interested or wanting representation, it's best to do it well ahead of the time that the 10 days runs. That way your attorney will have ample time to speak with you about the grounds for the eviction, what the landlord is alleging you have done or haven't done, and allow them enough time to contact the court and make an appropriate response within that 10-day period. And again, if you want to request a jury trial, it has to be done within that time period also. And it has to be done in writing. Now, if you have a bench trial, that's normally going to be set up pretty quickly after you contact the court, usually within a few weeks. And a bench trial is essentially the judge is going to decide whether or not your landlord has proven to them that they have a grounds to evict you from your dwelling. The court will require the landlord to present a case against you and to prove by what's called a preponderance of the evidence that they have a lawful grounds in South Carolina to evict you from your home. And you will also get an opportunity to present a defense. And of course, if you're represented by an attorney, they will have an opportunity to cross-examine the landlord, will have an opportunity to make any appropriate motions in your favor, and will also have an opportunity to present your defense. And a bench trial, the judge makes the decision. They're the decider of the facts of the case, and they apply the law and will ultimately decide whether or not the eviction is warranted. If you ask for a jury trial to determine whether or not the landlord has a right to evict you, in some counties in South Carolina, they're going to require you to mediate that case with your landlord. And oftentimes that means you will meet in a courtroom or another facility with the landlord with a third-party mediator who is there to assist the parties in trying to come to an agreement. Oftentimes eviction cases are difficult to settle, but it's not unheard of. But mediation can prove to be a valuable tool in trying to reach a compromise or an agreement with your landlord that allows you to stay in your home and satisfies them of any potential or alleged violation against you. Now, if you do get summoned to court, either through a bench trial or a jury trial, what you'll receive from the court is called a summons. And essentially what a summons is a document that requires your presence in court and notifies you of the date and time of either your bench trial or your jury trial. Again, in the case of a bench trial, the judge is going to decide whether or not you're to be evicted, and in the case of a jury trial, the jury of your peers will decide the facts. At the end of a particular eviction case, if the judge or the jury decide that your landlord has presented evidence that would allow him to evict you, the court will issue what's called a writ of ejectment. And that document looks like this. Now, the writ of ejectment is a document that gives the court the ability to remove you from your home. And that has to be served on you by the sheriff's department. If it's not personally served on you, then it has to be attached to the most conspicuous part of your unit, which is oftentimes your front door. And what the document does is notify you that you've got 24 hours to voluntarily vacate the premises. And that if you do not vacate within that time, after 24 hours, a deputy sheriff can enter the premises using only as much force as necessary to effectuate the ejectment. Oftentimes, in my experience, most magistrates, if they do rule against you and order you to be evicted from your home, will allow you some time and ask you how much time that you would need to move. They're not required to do that, but they oftentimes they will do that. So it has to be a reasonable period of time. Most of the time, it will not exceed 7 days. So just know that if you are evicted through the judicial process and a writ of ejectment is issued, by law you have to be out within 24 hours, but oftentimes the courts will work with you to allow you a few more days past that time to move. Also, if you are evicted, the next step in that process is, if you feel like you want to challenge whether or not that eviction was lawful, is there's two things that you can do. The first thing that you can do is to ask the court for what's called a new trial. And the magistrate's court can assist you in filling out the paperwork to request a new trial. You have to do that within 5 days from the date the writ of ejectment is issued. The second thing that you can do is to appeal it to the circuit court. They have appellate jurisdiction over the magistrate's court in evictions. You have 30 days within which to notify the magistrate's court that you're appealing the writ. Now, of course, if the writ of ejectment requires you to be out within 24 hours, or if the court allows you 7 days, you're going to want to file your appeal much quicker than the 30 days. If you do file the appeal, the circuit court will stay the execution of the writ, which means that the sheriff's department will not come and remove you and your belongings from your house pending the appeal. What you'll also have to do is to file what's called an undertaking. And an undertaking basically just states that while the appeal is pending in the circuit court, that you agree to pay rent as it becomes due, in whatever amount that may be.